You're listening to the Evil Orphan murder trial of Dima Tower from the Hidden Killers podcast and True Crime Today.
Ladies and gentlemen, I'm going to ask you to think about the jury instructions and what you heard on Monday about sympathy. You saw the defendant sobbing here in the courtroom. We had to actually take a break. I think it was on Wednesday during the defense's opening statement. And then again yesterday when the defendant took the stand. He put on quite a display of emotion.
Overruled. Let's move on from this, okay?
He put on quite a display of emotion. Hold him accountable for what he did. You may not have sympathy enter into your deliberations. Your job is to look at the evidence and see if the evidence comports with the law of first-degree murder. You may not have any sympathy for Robbie or Jennifer Tower or the defendant. And that's hard to ask human beings. And you may even have sympathy for all three of those people. But they cannot influence your decision. That cannot influence your decision. You have to compartmentalize that sympathy if you have any. Because the law says that you must judge the defendant on the evidence and the law. Hold him accountable for what he did, ladies and gentlemen. Thank you.
Vince, when you're ready.
Like we talked about at the beginning of this case, Mr. Tower's words still hold truth. It has a lot to do with everything that I've been through and everything that I've seen. And you've heard a lot of evidence in this case, and frankly, a lot of it was not disputed. The facts and circumstances of the tragic events of August the 31st of 2023 are not materially in dispute. Robbie Tower is deceased. Jennifer Tower is deceased. Those things occurred because of acts by Dima Tower. That is not in dispute. What is in dispute is whether or not Dima Tower had the rational, conscious intent to commit the homicides prior to them occurring. That is what is in dispute in this case, and that is what we have been asking you to focus on and not get sidetracked into different areas. The judge has instructed you that you have to presume Mr. Tower to be innocent before you start. We kind of dialed that back a little bit and said, look, before we even start this trial, I want to make sure that we're clear about what we're asking of you. And what we're asking of you is to make a decision about one simple thing. And it may not seem that simple, and it may seem very complicated to get inside the head of somebody else. And it is. It's complicated. The state has the burden of proving these crimes beyond and to the exclusion of every reasonable doubt. I know the state will say that most of what we've been talking about is trying to invoke sympathy for Mr. Tower. That is not the case. It is important, if you're making a decision about somebody's state of mind, that you are exposed to them so that you can make an informed decision. There's a lot of talk in the jury instructions about people of ordinary judgment making decisions. And what the judge has instructed you is that it's up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should be relied on in considering your verdict. We talked during jury selection about the fact that you don't leave your personal life experiences at the door. You bring those in because they form your common sense. And you can make the determination as to whether or not it's significant that Mr. Tower couldn't look me in the eye, couldn't look the state attorney in the eye, couldn't look the detectives in the eye at any point in time. That is something that is common for certain people. And when we're talking about individualized consciousness of guilt, every individual reflects differently. Every individual thinks differently. So if we're talking about the fixed time for reflective thought, it's important to consider all of the factors as to whether or not Mr. Tower had sufficient time for him to make reflective thought. Given his history, whether or not the killing was done after consciously deciding to do it. I would submit that Mr. Tower doesn't have the ability.
I'm going to object to this, and may we approach?
No, I'm going to sustain the objection.
Okay.
Sustain the objection.
Thank you.
I'll disregard the last statement by defense counsel.
The question of premeditation is a question of fact to be determined by you from the evidence. And the judge instructs you, again, use your common sense. Think about what evidence is reliable and what evidence isn't reliable. As Mr. Tower indicated, when there was discussions with law enforcement, he was concerned that there were misstatements, misunderstandings, which would be something you would understand from somebody who was in foster care in a foreign country, who didn't know the language before he got here, who learned the language himself by small talk, who was obviously awkward and uncomfortable. You can make a determination as far as all of those things, as to what weight you put on each piece of evidence and what weight you assign. Because like we talked about from the beginning, each of you individually has a verdict. And collectively, as a jury, you make a decision. But it is important for each and every one of you to have your voices heard. It's important that you take time to deliberate and make a determination as far as what culpability Mr. Tower has. I would suggest to you that the evidence presented leads to a manslaughter conviction. And we would ask that you come back with that verdict. Thank you.
State rebuttal when you're ready.
Thank you. Defense counsel argued that defendant told you yesterday, and he did, that this has a lot to do with everything I've been through and everything I've seen. You've heard no evidence, zero evidence of the defendant and what he saw and what he's been through. You are not.
Burden shifting?
I'll overrule the objection. I'll just remind everybody, there's no obligation or burden on the defense to do anything. You may continue.
The defense has no burden. But when you hear arguments that defy logic, you can reject the arguments by the defense. The defendant doesn't have to prove anything in this case, but he did. He proved everything in this case when he took that stand yesterday, and he said, I was sitting in the car thinking about it before I went into the house. I thought about killing my parents before I went into the house. So again, does the defense have to prove anything? No. Is it my burden? Yes. And I urge you to hold the state to its burden. But you have heard no evidence, absolutely no evidence, about what the defendant has seen and what the defendant has been through. And that is not burden shifting. That is simply a fact. The defendant described this as rage, but not rage that developed suddenly from a sudden event, some altercation with his parents, something that would make an ordinary, reasonable person lose self-control. This wasn't something sudden that happened that made Dima Tower lose his normal self-control and go in there and stab his parents. As I said earlier, his parents were fast asleep in their bed. They posed absolutely no danger to him. They did nothing to upset him or provoke his rage that night. I don't know where his rage was fostered, and neither do you. But he had rage for his parents when he was sitting out in that car, and he acted on that rage. This was not manslaughter. This was not a crime of passion. He sat out in his car and thought about it. And again, you're going to hear instructions about speculation. They're in your jury instructions. On Monday night, you took an oath to well and truly try this case based on the law and based on the facts, not on speculation. In fact, the jury instructions forbid you to speculate about the defendant's past or what he's seen or what he went through when his mother died. That's pure speculation, and you may not do that. Do not let yourself be persuaded because the defendant tried to and was prevented, correctly so, from talking about his past, because that is not why we're here. We're here because the defendant killed his parents. The law doesn't change for people to fit their situations. Whether you're an executive of Coca-Cola or whether you're a kid from a bad neighborhood, whether you graduated from Northport High School or you graduated from Harvard, the law is the same for every single person. And what he went through when he was a kid has nothing to do with this crime that he committed. Don't be persuaded that because the defendant had a horrible childhood and he ended up in an orphanage, that he's somehow justified in doing what he did. Those photographs say everything. There is no justification for that. I'm asking you to think about the facts and think about the law, and only that, because there is no room for sympathy or speculation in your job. I'm asking you to hold the defendant accountable for what he did. I'm asking you to find him guilty of killing Robbie Tower and Jennifer Tower after premeditation. I'm asking you to hold him guilty of first-degree murder on both counts, and also for fleeing to elude law enforcement officer with lights and siren. I thank you for your patience and your attention.
That concludes the closing arguments. Folks, as you might know, I think we talked about this at jury selection. We chose to have two alternates because we were going for the whole week. If someone got sick, we would have had them fill in. Do you folks remember your numbers from day one? Remember you had a paddle in your hand? I'm going to try to see if we can identify our alternates by number. They were number 45, initials SM, is that right? Okay. And juror number 50, JP. Where are you? Do you folks have any personal belongings back in the jury room? Yes? While I'm going over this last instruction, why don't you go with Carl, the bailiff, and gather your personal belongings. When you're done, Carl, give me about maybe a minute or two. We'll bring you back in. You can just come over to the side. You've spent a whole week with these folks. You can say bye to them as they're walking out in transition. I'm going to speak to you just for a bit before I send you folks home, okay, the alternates, okay? Everybody can remain seated while the alternates head out with Carl. For the rest of you, you all comprise our jury, so you can turn to that last jury instruction in your packet. I'm going to read that to you. In just a moment, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with any person outside the jury about the case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in the case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, or laptops, or other electronic devices in the jury room. The rules do not allow you to keep those or bring those into the jury room. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the bailiff. These devices will be safeguarded by the bailiff while you deliberate. I think what Carl will do is he'll put a cart outside your jury room. If you want to make a call to a loved one, let them know you're well. Turn your phone to silent or off. That includes Apple Watches, electronic watches, iPads, any electronics. If you can turn those to off or silent, just put them on the cart outside the jury room, okay? If you need to communicate with me for any reason, send a note through the bailiff. If you have voted, do not disclose the vote in the note. If you have a question, I will talk with the attorneys here in court before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. A, some of these exhibits will be sent into the jury room with you when you begin to deliberate. And B, if you wish to see any of these other exhibits, please request that in writing. Both apply in this case. What we decided is we're not going to send any of the knives back to you in the jury room. There was a butcher block, you may recall, with some knives and then 2 other knives. You're entitled to see those if you wish. So that would be a note by a 4-person sign saying we'd like to see the knives, for example. What we'd do in that case, I'd talk about it with the attorneys. We could either have a bailiff just bring them into the jury room, have you have access to those for a few minutes and then collect them, or we can bring you back into the courtroom and have a bailiff walk in front of you with those as well, okay? But other than the knives, all other evidence will go back with you. Again, you have the jury cart back there if you want to view or watch any evidence that's in the form of electronics. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. All right, folks, at this time, if you can take your writing implement, your notepads, and your jury instructions, and head on out with Carl, okay? To my alternates, go ahead and just move a little bit so the other jurors can go by. We'll be at recess until we have a question or verdict. Please leave your cell phone with the clerk. Please stay within 15 or so minutes so that we can all get back into the courtroom. Folks in the audience, we're not going to individually, of course, call any of you. If you want to be present, leave your number with the attorneys, and they'll assist you in letting you know when we're back in court, okay? All right, we'll be adjourned until we have a question or verdict. Folks, thank you. You don't need to tell me if you're upset or happy, but
More of the Evil Orphan murder trial of Dima Tower is coming up. Press subscribe now so you don't miss a moment from the Hidden Killers podcast and True Crime Today.